Hi, it's me, Brodie McLeod, still at the lodge at Signet Stokes Western-super-Mare Hospital site, and I've got a special Sunday, probably quite long and boring, but maybe really interesting and quite scandalous edition of the Wastecast for you today. I've just created this document using my computer and Gemini AI. I will make a link to the PDF available in the description of this video, so if you can't be fucked to sit there and listen to me reading it out for the next 40 minutes, you can just download it and read it in the bath if you've got a waterproof phone, or when you're having a shit if you're that way inclined, or anywhere really, on the bus, train, plane, in your bedroom, in the lounge, dining room, anywhere really. Anyway, let's tell you what I will do. Just put my hat on, because I've got male pattern baldness. I've still got the labels on my hat because I'm a total dick. But yeah, I'll read you the document. It will take a little while, but it's very relevant to me. So what I'll do is I'll put my head in this little thing. I can't do that while the camera's already in use. And without further ado, I'll get into this document. It's titled A Narrative of False Imprisonment and Criminal Neglect. Based on my research, that's exactly what I'm the victim of at the moment. I do meet the criteria for a section. I was in a position where I wanted to take my own life, and that's continued throughout the course of my detention up until the sort of beginning of 2025 when things started to improve. I have had good treatment from some of the staff at Signet Healthcare, and I've had good relationships with some of the service users too. Overall, I'm kind of particularly unhappy about the various compliance, legal guidelines and regulatory framework breaches that have taken place, and there's nobody that can really explain them to me or justify them. But at the same time, I have reluctantly reported this to the police now. Yesterday I phoned up and made a police report, and they said they're going to come visit me at some point, take a statement. I'm not interested in trying to litigate against Signet and relieve them of vast sums of money, or the NHS trusts or Elysium Healthcare or any of the parties mentioned in this document necessarily, but I would like to enforce it, because I think that if I let them get away with doing it to me, they might do it to somebody else, and I think we've all got a duty. Us British people love to complain, don't we? And this is just a massive complaint, having a good old piss and moan about things not being done properly. Some of it's quite serious, and has endangered my life and my civil liberties. I've left the human rights bit out of this. There's like a whole nother bit about human rights, but I'll just read this because it's going to take me a while, and I've already been speaking for 3 minutes and 45 seconds. So, my name's Brodie Nathaniel Diorsa McLeod, and I'm being falsely imprisoned. This document is the comprehensive narrative of the criminal activity that's led to and sustains my false imprisonment, a criminal offence, the rationale for which is robustly outlined in this document. My detention is not the result of a single error, but a series of deliberate, interconnected and criminal acts perpetrated by multiple organisations and their staff. These organisations include Avon and Wiltshire Mental Health Partnership NHS Trust AWP, Devon Partnership NHS Trust DPT, Signet Healthcare, Elysium Healthcare, University Hospitals Bristol and Western NHS Foundation Trust UHBW, North Bristol Trust and South Gloucestershire Council. The individuals liable for prosecution and sentencing from these crimes include, but are not limited to, responsible clinicians, ward managers, social worker Catherine Fall, mental health act administrators, registered mental health nurses and hospital managers, and all other staff who have sort of knowingly participated in the crimes that are detailed in this document. These acts fall into three main categories. 1, unlawful commissioning. The entire basis for my detention is void because the wrong NHS body is commissioning my care, making a lawful discharge impossible. Falsified legal documents. 2. The MHA paperwork used to detain me is fundamentally invalid, containing factually impossible dates and errors that were unlawfully scrutinised. 3. Criminal neglect and data concealment. There's a systemic and total failure to record or transmit any of my medical treatment data to my GP, an informational blackout that places my life at immediate risk and serves to conceal the evidence of this false imprisonment. So the core illegality, unlawful commissioning and false imprisonment, hit the links there if you want to find out more from the PDF. The most fundamental reason my detention is unlawful is twofold. First, there's no legal path for me to be discharged because the commissioning of my care is a broken procedure based on a deliberate distortion of NHS guidance. Secondly, and just as critically, this broken procedure is only possible because both the trusts, so Devon Partnership Trust and AWP, are actively refusing to recognise an easily verifiable objective fact that my ordinary residence is and has been Bristol. Their refusal to accept this fact is profoundly and transparently absurd, as they're ignoring irrefutable evidence I have provided, such as tenancy agreements and my registration on the electoral roll. The absurdity is compounded by the fact that both NHS trusts are disputing a reality that they themselves created. So NHS Devon Partnership Trust placed me in supported living at 246 Wells Road, Knoll, in 2021. There's a tenancy agreement if you want to have a look at it. Same goes for AWP. I spent most of 2023 in hospital. AWP placed me in supported living in Talbot Avenue at Bristol in 2023, and there's a tenancy agreement for that as well. So they can't, then they're trying to deny that I'm a Bristol resident. They both put me in Bristol. So I was an AWP patient, then they changed it to DPT, and then they both said, you're not a Bristol resident. And they've both put me in flats in Bristol after I've been sectioned. In 2021, I was informally sectioned, and in 2023, I was sectioned under Section 3 of the Mental Health Act. And they both put me into safe accommodation. It's part of what they call 117. You'll read about that in a minute. It's a package of care to make sure you don't relapse. So they don't spend thousands of pounds and months of hard work treating people with mental illness and then discharge them to be tramps on the street, because obviously that's going to affect your mental health. So you have to have safe accommodation to return to. That can take a variety of manifestations, but I shall go on with this trope. For these very trusts to now turn around and claim against all evidence that their own procedural actions, that my ordinary residence is not Bristol, is a ridiculous and dishonest position. It suggests a clear and willful motive for obfuscation, which may be linked to previous unlawful detentions prior to these placements that the trusts are now attempting to conceal. I mean, it's the only reason I can think that they're denying their own actions. This document will now provide a deep dive into the specific laws and facts that prove this criminal conspiracy. So the facts: I am and have been ordinarily resident in Bristol for years. This is AWP's area. My current detention began in Bristol. Therefore, AWP is by law the responsible commissioner for my care. The unlawful act. In January 25, following my exposure of misconduct by a social worker, Catherine Fall, assigned by the AWP-led South Gloucestershire Recovery Team, my funding was arbitrarily and unlawfully switched. AWP, the correct commissioner, has refused to fund my care. Devon Partnership Trust, a trust 100 miles away in Devon, has unlawfully taken over. So here's the definitive proof. Part 1 is the unlawful acceptance. There's a letter which you can read at your leisure, in the garden if you wish. A letter from DPT dated the 9th of October confirms that they are commissioning my care, even while admitting I was not living in Devon. I don't live in Devon. They justify this by misusing the Worcester judgment. I can't say it properly, and you probably don't understand it, even if you do read the guidance, but just put it into AI and ask them how it works, and you'll be able to find out. The Worcester case is case law about 117 and ordinary residents, but it has nothing to do with healthcare funding. So the judgment, claiming a historic Section 17 duty from 2019 binds them to me forever, is a direct and deliberate misapplication of the rules. I had no idea why it says $ and notes there. That's awesome. Bit of AI document creation. Ignore that bit. Deconstruction of DPT's flawed logic. Letter to dpt.com. You can view that letter. This letter is a deliberate distortion of the rules. Here's a deconstruction of its flawed logic. So they admit the core fact. The letter explicitly states Devon Partnership Trust remains responsible even though you were not living in Devon at the start of this current detention. This confirms that my ordinary residence is not Devon and that they are aware of this fact. They hide behind a misinterpretation, so their entire justification hangs on the Worcester judgment, claiming that originating ICB retains responsibility even if the patient moves. That's what it says in their letter. This is deception. The Worcester guidance, as clarified in the NHS Who Pays document, was designed to ensure continuity of care for patients who are placed out of area by the NHS. It was not intended to abolish the fundamental principle of ordinary residence, which is the primary legal test. It does not mean that a person who voluntarily moves and establishes a new settled life in a new area, as I did in Bristol, is tied to their original commissioner forever. By applying this Worcester rule, DPT is willfully ignoring my primary legal test of my established ordinary residence in Bristol, which is the only one that matters. The definitive proof, part 2, the unlawful refusal. So a letter from AWP, which I got on the 23rd of this month, confirms their refusal to take on commissioning responsibility, completing the legal arrangement. There's another dollar bill note word there, which is some weird formatting when I export it to docs. Deconstruction of AWP's flawed logic in the letter. So the second letter that I got, this letter is the other half of the crime, demonstrating a clear collusion with Devon Partnership Trust by using the exact same flawed logic. So they admit my location. The letter was explicitly acknowledgement that I was resident in Bristol, quote, prior to my most recent detention. This is a formal admission from AWP that my ordinary residence is in their area, Bristol. They formally refused their duty. Despite this admission, the letter is a formal refusal by AWP, the correct legal commissioner, to accept their statutory responsibility for my Section 117 aftercare. They used the same flawed excuse. They justified this legal refusal by citing the exact same misinterpretation of the Who Pays guidance as DPT, claiming the historic Section 17 duty from 2019 means that DPT retains responsibility even if the patient moves to a different part of the country. This is proof of collusion. The correct commissioner, AWP, is using a flawed rule to refuse its duty, while the incorrect commissioner, Devon Partnership Trust, uses the same flawed rule to accept it. This coordinated action is the mechanism of the crime. This unlawful commissioning switch is not a simple administrative dispute. It's the central mechanism that transforms my case from a civil matter of unlawful detention into the crime of false imprisonment. Click on the link to see what that is if you'd like to know more about it. It's crucial to make this distinction. The civil dispute might involve an unlawful detention where, for example, like procedural errors are made in good faith and are subject to an appeal or a judicial review. But a crime of false imprisonment, which is a common law offence, is committed when there's an intentional and unlawful deprivation of a person's liberty. My situation falls squarely into the criminal category because the evidence details below shows this is not an accident or a good faith mistake. The coordinated, collusive and fact-defying actions of AWP and DPT in direct opposition to established law and their own records demonstrate a clear intent to create a jurisdictional void. This act, combined with the forged legal papers and concealment of medical data, forms the basis of the crime, as the following analysis will prove. So deconstruction of the Who Pays guidance. This is the document they're saying supports their actions, which doesn't. You can click there and review the guidance. The trust's justification for this unlawful arrangement is based on the deliberate misreading of the NHS Who Pays guidance, version 5, August 2025. Here is an analysis of what the guidance actually says versus how it's been misused to justify AWP having no further business with me because somebody could be arrested for you'll see when I read the rest of it. So the default rule, which AWP and DPT are illegally ignoring, first of all, you've got the entire guidance, right, is built on the default principle of ordinary residence, which is established by where a patient lives and is registered with a GP. I've lived in Kingswood and my GP is Orchard Medical Practice in Kingswood, Bristol. Verbatim quote, page 10. It says, the ICB of which the patient's GP practice is a member is responsible for commissioning. This is the default position unless any of the rules set out in this guidance states otherwise. Analysis, my GP is in Bristol. My tenancy is in Bristol. My ordinary residence is in Bristol. Therefore, under the default primary rule of the guidance, AWP is the only lawful commissioner for my care. The exception, which AWP and DPT are misusing, the trusts are ignoring the default rule and claiming a specific exception relating to Section 117 aftercare, and this case law, Worcester versus the government judgment, applies. So the verbatim quote, page 31, paragraph 5 to 6, the ICB that commissions the patient's Section 117 aftercare will be the ICB that was responsible for the patient at the point they were first detained under Section 3. This responsibility remains with that ICB regardless of any change in residence. So the correct interpretation, the deception, the trusts are presenting this exception, paragraph 5.6, as an absolute permanent rule that abolishes ordinary residence forever. This is a fraudulent interpretation. The rule was clarified to analyse to prevent ICBs from dumping patients by placing them in out-of-area care. So if you lived in like London, you might get sent to Bristol to be in a hospital if there's no beds in London. So out-of-area care and then terminating the Section 117 duty, leaving them stranded. It was not intended to create a situation where a patient who voluntarily moves to a new city, establishes a new settled life, signs new tenancy agreements, registers with a new GP and lives there for years, as I did in Bristol, was still chained to their original commissioner. My current detention in 2024 is a new event, starting from my established ordinary residence in Bristol. The trusts are legally and retrospectively applying a rule from a previous and separate period of care, 2019. I was actually first sectioned by Devon Partnership Trust on the 27th of July 2012, but they seem to think that the 117 duty started in 2019. I was actually sectioned by Devon Partnership Trust in 2018 at Signet Taunton in November. But anyway, they're misusing an exception to create a jurisdictional paradox, which is clear and willful misapplication of the guidance. Don't know why there's a space in between that paragraph there. More quality AI formatting. Breach 1. The Mental Health Act 1983, Section 117 aftercare. This law dictates who is responsible for planning and paying for a patient's aftercare, which is the entire purpose of Section 3 detention. So the Mental Health Act 1983, Section 117, you can look at it. It says, if you read it, it shall be the duty of the Integrated Care Board of the local social services authority to cooperate in the provision of aftercare services for any person to whom this section applies. The duty under subsection above shall continue until such time as the Integrated Care Board and the local social services authority are satisfied that the person concerned is no longer in need of such services. So how they've broken the law in the Mental Health Act Code of Practice, Chapter 34.11, it clarifies this duty falls to the ICB and local authority of the patient's ordinary residence. My ordinary residence is Bristol. The legal duty to plan and fund my discharge, that's the S117, that's getting out of hospital, not the healthcare while you're in it, belongs only to AWP and Bristol or South Gloucestershire Council, because I lived in Kingswood, which is just in South Gloucestershire. AWP is actively refusing this duty as proven by their letter. So Devon Partnership Trust, the wrong ICB, is commissioning me as proven by their letter. It has no legal authority or jurisdiction to plan a discharge into Bristol. So there's no lawful body able to plan my discharge. A detention without a lawful purpose or a legal path to discharge is not in accordance with procedure prescribed by law, which engages my human rights under Article 5 and also constitutes false imprisonment. So breach 2, misconduct in public office and potentially fraud, which is a common law offence. The catalyst for this unlawful switch was my exposure of a social worker, Catherine Fall. The facts: in November 2024, Ms. Fall was assigned to my case. She refused to provide her email, NHS email or work number. I contacted South Gloucestershire City Council, who confirmed in writing on X that they had no record of me on their database and that her behaviour was circumspect. Then they tried to cover it up. So after I exposed this, a false allegation of malicious communications was immediately made against me by her team, and she was removed from my case. I was immediately treated as guilty by both the South Gloucester Recovery Team manager and the Signet staff with no verification or investigation. Like, I offered my phone, to just check for messages to my social worker, even for the police to have a look through it and forensically analyse it to prove my innocence. But this was ignored. This refusal to investigate establishes a very strong motive for the allegation to be false, acting as a convenient pretext to remove the busted social worker from my case. To be clear, She was a genuine social worker. I did verify her credentials with Social Work England, but she was operating off the books, effectively moonlighting. So the council said they had no idea. This clandestine activity fits perfectly with the entire contextual narrative of my criminal false imprisonment. This was not a minor interaction. She attended like multiple ward rounds via Microsoft Teams and in person too. She also conducted a face-to-face meeting with me to discuss my confidential mental health information and to plan my discharge into a specific location of her own arrangement. This secret and unrecorded plan to move a vulnerable detained person to a location of her choosing without any official record, lawful authority or oversight is a terrifying abuse of power. This act of attempting to move me illegally and in secret for an unknown purpose has characteristics that actually align with the definition of human trafficking. Read the legislation and see what you think. How the law is broken. A public officer, a registered social worker acting improperly, her employer, South Gloucestershire Council, having no record of her work with me, and the subsequent cover-up via false allegation is a textbook case of misconduct in a public office. I'll put a link. I did put a hyperlink in to the tweet from the council, but I'll put that in the description as well if I can remember to. Section 2, invalid legal documents, the falsified authority for detention. So the commissioning of my care is not just unlawful, the foundational paperwork used to detain me is also fundamentally invalid. I was transferred from Elysium Healthcare in Warrington on the 8th of August 2024, a fact proven by my own discharge summary. However, Signet Healthcare's legal documents don't match this reality. Upon analysis, the statutory Mental Health Act papers and the hospital's own medical legal scrutiny checklists are riddled with so many gross inaccuracies, impossible dates and procedural errors that they're not legally valid. These are not minor typos, they're fundamental failures that invalidate the very authority used to detain me. Have a look at all these documents using the links in the PDF and also check out what criminal neglect means, because that's the next bit I'm going to read you. Informational blackout. My primary care records, which were provided by the NHS on the 4th of May 2025, prove that there's been a systemic and total failure by Signet Healthcare to record or transmit any of my medical treatment data. This creates a complete informational blackout for the entire period between my date of detention, July the 9th, 2024, and the date the records were supplied. While I can at present only account for the gross and catastrophic failure between these dates, it's highly likely that this criminal censorship has continued to the present date. This period covers my initial sectioning by Bristol Royal Infirmary on the 9th of July, my transfer to Eve Ward at Elysium Hospital and St Mary's on the 21st of July, and then my subsequent transfer to Signet Qstoke on the 8th of August 2024. Also covers my time on Hayward Ward, which is an acute psychiatric ward, and my transfer at the beginning of June 2025 to the Lodge, a rehabilitation ward on the same site. The obfuscation of treatment data is massive and identical across all three hospitals. For example, oral medications I received at the BRI are missing. They're just not on the records at all, just as my treatment records for Elysium and Signet are as well. All these transfers and treatments are completely undocumented on my GP record. My GP record, which I obtained via subject access request, proves this. This is a non-exhaustive list of what's missing. So all my intramuscular, they're called depot injections of antipsychotic. That's really strong medicine that you get injected into your buttock. All the prescriptions I've had for opiate painkillers, oral antipsychotics, sedatives, a vaccination, and a significant change in my diagnosis. Antibiotics too, quite a few times. To be clear, it's not a clerical error or an administrative failure. Like, it's a deliberate, systemic informational blackout. It's an intentional act of data suppression, which constitutes the specific crime of willful neglect and places my life at immediate and profound risk of fatal foreseeable medical errors. So, breach 3 is the Criminal Justice and Courts Act 2015, Section 20, ill treatment or willful neglect. This law makes it a specific criminal offence for a carer to neglect a patient in a way that endangers them. So, if you want to look at that Criminal Justice and Courts Act 2015, Section 20, what it says in that is that it's an offence for an individual who has the care of another individual by virtue of being a care worker to ill-treat or willfully neglect that individual. How they've done that? Well, willful neglect is precisely this, a systemic total failure to perform the most basic duty of care, recording the administration of potent medications. So If I'm transferred to an A&E, the doctors will look at my GP record. They'll see nothing about my current medications. Like if I collapsed in the street or got hit by a bus or whatever, if they administer a common drug like the antibiotic erythromycin that interacts with my unrecorded antipsychotic, it can prolong QT interval of my heart, triggering fatal arrhythmia. The liability, every nurse who administers my medication fails to ensure it's recorded on the central NHS system as committing this offence. This criminal liability also applies to any consultant psychiatrist acting as my responsible clinician, all the ward managers who have emailed about my medical records, mental health act administrators who are supposed to make sure as well that everyone's records are being transmitted and updated with NHS, and the trusts themselves, who also should have noticed that there was absolutely no information being conveyed. They've attended multiple ward rounds and heard me being prescribed various different medicines by my consultant psychiatrist, and they haven't noted that on the NHS primary care record, and they haven't noticed it. All of them sort of should and would have been aware that no information was being recorded during this systemic failure. Breach 4 is the Health and Social Care Act 2008, 2014, Regulation 17. Have a look at that link. This law places a statutory duty on the provider signet to maintain good records. Contemporaneous is the word they use. CQC Regulation 17 says that systems or processes must enable the registered person to maintain securely an accurate, complete and contemporaneous record in respect of each service user, including a record of the care and treatment provided. How this law is broken: Signet Healthcare has failed to maintain a complete and contemporaneous record. This liability also extends to Elysium and the Bristol Royal Infirmary, as all three providers administered medical treatments and medicines that are missing from my primary care record. There is some record, but it's not all on there. From BRI, that at least. That's what I'm specifically referring to them. It's on my NHS app, but it's not on my primary care records, and it's not comprehensive or exhaustive at all. This systemic failure by all three organisations is a prosecutable offence for the CQC and creates a clinical minefield that puts my life in danger, which isn't very good for me. Additional criminal offences and conspiracy. The failures detailed above are not just individual breaches. They interconnect to form a pattern of behaviour indicative of more complex, coordinated criminality designed to conceal the primary offence of false imprisonment. So, conspiracy to pervert the course of justice is a law. Click on the link. Once again, this is a common law offence. It's committed when two or more people agree to do something that will interfere with the administration of justice. So, how they apparently have broken that law, I'm alleging. When these facts are viewed together, a clear narrative of a conspiracy emerges. First, my NHS Funding Commissioner, Integrated Care Board, is unlawfully switched, creating a jurisdictional void. Second, my detention is authorised using falsified legal documents. And third, medical blackout is implemented to conceal all evidence of the treatment I'm given during this false imprisonment at the BRI, St Mary's Hospital, Warrington and Signet Hospital, Qstoke. Finally, my existing records are corrupted with coordinated redactions to destroy their evidentiary value. These are not separate mistakes. They are synchronised components of a single calculated conspiracy to falsely imprison me and conceal the evidence. Breach 6, this is one of the most serious ones. So Corporate Manslaughter and Corporate Homicide Act 2007. This law addresses corporate liability for death caused by gross negligence. As you can see, today I'm still alive, but what the law says about that is that an organisation to which this section applies is guilty of an offence if the way in which its activities are managed or organised causes a person's death, and B, amounts to a gross breach of relevant duty of care owed by an organisation to the deceased. So how it's broken: this offence is contingent on a death occurring, but evidence proves the threshold for a gross breach of the law has been met. So the healthcare providers, Signet, Elysium and BRI, owe me a relevant duty of care. The way their activities are managed or organised, specifically the systemic, and total failure to transmit any medical data to my GP, is a gross breach of that duty, which has put my life at risk. This is not like an individual error. It's a failure of the organisation's systems of governance and data management at a senior management level. So the danger this informational blackout creates is not hypothetical. It's a series of real-world foreseeable medical disasters. Because I'm on a long-acting injection right now of aripiprazole, any emergency medical team operating from my blank GP record would be acting blind with potentially fatal consequences. So here's some examples. Cardiac arrest. If I collapsed in the street and I got taken to A&E and I'm unable to communicate, the A&E team checks my GP record and it's blank. I don't know. It was blank up to May, to be disambiguous. I don't know that it's still blank, but I'm assuming it is, because everybody has, for the first sort of 10 months that I was here, it's completely blank. So yeah, I've sort of put in another subject access request yesterday. But yeah, at the moment I'm on aripiprazole, and if that hasn't been transmitted to the NHS, it hasn't been for the between July 2024 and May 2025. A drug known to carry a risk of QT prolongation and irregularity of the heart's electrical rhythm. So to treat a suspected infection or nausea, they administer a very common drug like the antibiotic erythromycin or the anti-sickness drug or densitron. These drugs also prolong QT interval. That's like the electrical rhythm of your heart. The cumulative effect of the unrecorded aripiprazole and the new drug triggers something called TDP for short, or Toussaint's de point, a life-threatening cardiac arrhythmia that leads to cardiac arrest and death. This death is direct foreseeable result of the blank record. Here's another scenario: cardiovascular collapse during emergency surgery. So I'm admitted for emergency surgery, like say for appendicitis. The the anaesthetist checks my records and sees nothing. They're unaware I've got a long-acting antipsychotic in my system. Aripiprazole, the drug that I'm on right now, is known to interact with general anaesthesia, causing significant hypertension, which is a severe drop in blood pressure, and potentially dangerously increasing the sedative effects of opioids and benzodiazepines used in the procedure. So the anaesthetist, blind to this risk, administers a standard dose, causing my blood pressure to crash, and that would be resulting in a cardiovascular collapse during the operation, or causing severe respiratory depression post-operatively, leading to brain damage or death. Here's another scenario which fortunately hasn't happened but could happen: misdiagnosed neuroleptic malignant syndrome. So the risk, if I went to A&E with a high fever, muscle rigidity and confusion, the classic life-threatening symptoms of something you can get with a lot of different antipsychotics, very rare, it does happen, and it's called NMS, neuroleptic malignant syndrome. It's like a severe adverse reaction to antipsychotic meds. So the medical team could make a fatal error if they had a blank record and no reason to suspect neuroleptic malignant syndrome. They might misdiagnose me as having like sepsis or meningitis or something like that, and begin giving me completely the wrong medicine and completely the wrong treatment pathway. So the correct life-saving treatment for NMS is to immediately stop the medicine that's causing it, it's antipsychotic, and provide specific supportive care. Because the doctors are unaware I'm on this drug, they can't do that. And the NMS progresses, leading to multiple organ failure and death. In all these realistic scenarios, my death would be a direct consequence of the gross breach of the duty of care by the provider organisations whose failure to manage their data systems created the informational blackout that made safe medical treatment impossible. So forgery and counterfeiting, they aren't really plausible typos. So this law makes it an offence to create or use a false document with the intention of it being accepted as genuine. You can read the law on forgery and counterfeiting. What it says in it, which is relevant to this case, is that if a person says that a person is guilty of forgery if he makes a false instrument with the intention that he or another shall use it to induce somebody to accept it as genuine, or to his or another's prejudice. So what they did, the Mental Health Act documents containing factually impossible dates like a detention date before an admission date, they should both be the same. Scrutiny signed after the detention has expired are false instruments as defined by the Act. So they were made and used to induce the hospital managers, CQC and myself to accept them as genuine to the prejudice of my liberty. Likewise, the medical report, knowingly compiled with vast omissions, is also a false instrument used to create a false narrative of my care. Then you've also got like cybercrime, Computer Misuse Act 1990. That relates to the unauthorised and deliberate alteration of electronic records. What it says in that is that a person is guilty of an offence if he intends by doing the act to impair the operation of any computer or to impair the reliability of any data held in any computer, the intention need not be directed at any particular area. So how that law has been broken: the informational blackout, willful prevention of data from being written into central NHS computer systems, and the coordinated redactions, the deliberate alteration of data to remove my own name from my own medical records. Like, why the fuck would anybody do that? Are intentional acts designed to impair the reliability of my electronic health records. This was done to make them forensically worthless, so I couldn't take them to the police and say I've been kidnapped, basically, and this is who has done it, because they just say, well, you've just edited that PDF together and deleted somebody else's name from it. Who, what doctor or medical institution would redact a patient's own name? And they'd laugh me out the police station, And there's no other motive really to do that. It's not, redactions are like, you don't redact the information, the name of the person whose information it belongs to. I own the corporate rights and the intellectual property rights, to my own name. Nobody else does, and there's no reason for it to be deleted by 3 different trusts. So, yeah, they're intentional acts designed to impair the reliability of my electronic health records. This was done to make them forensically worthless and to obstruct any audit or investigation, thus concealing all the other crimes. That makes a lot of sense, really, if you look at it like that in context. Total lack of accountability and the path forward. Throughout this entire period, I've been met with a total lack of accountability. My attempts to raise the alarms have been systematically ignored. Multiple written notifications to hospitals' PALS teams, independent mental health advocates, hospital managers, registered mental health nurses, and consultant psychiatrists have produced no action, no investigation, and no correction. I spoke yesterday with an RMN. I said I wanted to report it to the police, and she facilitated it. And we'll wait and see. They said they're going to come out and see me, but the wall of silence has left me with no choice but to escalate this to law enforcement. I made formal police report yesterday to Avon and Somerset Police. As of yet, I've not had further response, but I was assured that officers will be visiting the hospital so that I can make a formal statement. This is the first step in ensuring my immediate safety and rectifying this unlawful situation. My aim is to be safe from the crimes alleged in this document, including false imprisonment, willful neglect, misconduct in the public office, fraud, conspiracy to pervert the course of justice, forgery, unauthorised modification of computer material under the Computer Misuse Act, and to ensure that I am, for the first time, lawfully detained and have a legal path to lawful discharge. It's also got manslaughter, it should say, in that list, and Homicide Act 2007. The combination of these systemic failures has left me feeling exceptionally vulnerable and actively endangered my life. If the investigation by Avon and Somerset Police is thorough and successful, it should, based on the evidence, result in multiple prosecutions. Summary of liable parties and potential prosecutions. The following is a summary of the organisations and individuals potentially whose actions, as detailed in this document, make them liable for prosecution. So organisational structures would be Avon and Wiltshire Mental Health Partnership, AWP, for false imprisonment, conspiracy to pervert the course of justice. They're common law offences, trial on indictment with a maximum sentence of life imprisonment. I don't know who would serve life imprisonment or that they would, but there is what it says in the law. Signet, Elysium Healthcare, and 2 NHS trusts from Southmead and BRI have committed the offence of ill treatment or willful neglect, breach of CQC Regulation 17, prosecutable regulatory offence for failure of good governance, corporate manslaughter by gross breach of duty of care, and conspiracy to pervert the course of justice, evidenced by the coordinated data corruption. Willful neglect carries a maximum sentence of 5 years on indictment. Corporate manslaughter and CQC breaches can result in unlimited fines for the provider. The council apparently would be responsible for misconduct in a public office for the actions of their off-the-books employee. I don't know if they were the one that exposed it. I think the council actually didn't have any knowledge of it, so I would probably argue that might not be accurate. It's generated by a custom gem, but yeah, I put a lot of information into it. Maybe fraud by false representation. I think probably the social worker would be the one in the wrong. The council were honest with me and open and exposed her on Twitter. Sentencing guidelines for misconduct in a public office, you can do life in that for that, and fraud carries 10 years. So responsible clinicians and ward managers also, I've tried to say and falsely imprisoned, and they're knowingly enforcing an unlawful detention, they should know what they're talking about. Ill treatment or willful neglect by overseeing systemic failure to record life-critical medication. They've prescribed me loads of different meds. I was on a different injection before. I've had sleeping tablets. I've had Valiums. I've had antibiotics. I've had melatonin. Melatonin isn't really that pokey, but I've had loads, and I've had loads of different things, loads of different injections and tablets and sedatives, lorazepam and clonazepam, and anyway, it's got maximums of life imprisonment and 5 years respectively. All involved RMNs potentially could be charged, because they're carrying out the unlawful deprivation of liberty and they're not updating my medical records. Willful neglect as the individual's administering medication, failing to record it. Only nurses can give you meds, and they have to go and put it on the computer every day and make sure that the NHS knows about it. But they haven't done that for me. That would carry a maximum of life imprisonment and 5 years respectively. The social worker who wouldn't give me any of her details, and then they tried to say that I was maliciously sort of messaging her somehow, and then just disappeared in a puff of smoke after she got shown to be acting criminally, might face charges for misconduct in a public office and fraud and human trafficking. Could do life in prison for misconduct and trafficking, or 10 years for fraud. The scrutinising doctors and the Mental Health Act administrators have basically committed false imprisonment and forgery under Section 1. Their role is to be the safeguard against unlawful detention. So they need to pay very close attention to the documents by signing off fundamentally invalid and factually impossible legal documents, false instruments as the law order sees them. They failed in this duty and became complicit in the unlawful detention. That also carries life imprisonment for false imprisonment, or 10 years for forgery. Anyway, that's the end of my... Hope you've enjoyed it. I'll put a link. I did have a hyperlink to the tweet from South Gloucestershire City Council saying that the social worker should have given me her phone number and her work email, firstly, and then they said, after it took them a couple of days to get back to me, but they were like, we've checked our internal database and we can't find any record of it. I'll leave a link to that in the description. I'll leave a link to my medical records in the description, and I'll leave a link to this PDF in the description. And hopefully I'll be able to get out of hospital, continue my life, help some people, rather than being such a cynical, insulting and accusatory person. But there's sometimes a bit of truth in things that seem like fiction, and sometimes a bit of falsehood in things that we believe to be true, and I guess the truth lies somewhere in the middle. But thanks for your 43 minutes. You could probably read it in about 14 if you download the document. So if you haven't done that already, do that, and tell everyone about it, because it's really scandalous. Cheers.